Namaskar viewers, hello and welcome to Sansad TV. I'm Tina Jha, you're watching Perspective. When justice is accessible to all, delivered in a timely manner and reaches every individual regardless of their social or financial background, that is when it truly becomes the foundation of social justice. This was the emphasis of Prime Minister Narendra Modi at the recently held National Conference on Strengthening Legal Aid Delivery Mechanisms. Addressing the gathering, the Prime Minister underlined that over the past 11 years, the government has consistently worked to enhance ease of doing business and ease of living, highlighting that more than 40,000 unnecessary compliances for businesses have been removed. Through the Jan Vishwas Act, over 3,400 legal provisions have been decriminalized and more than 1,500 obsolete laws have been repealed. Let's listen in.
साथियों, जब न्याय सबके लिए एक्सेसिबल होता है, टाइमली होता है, जब न्याय सोशल या फाइनेंशियल बैकग्राउंड देखे बिना हर व्यक्ति तक पहुंचता है, तभी वो सामाजिक न्याय की नींव बनता है। लीगल एड इस बात में बहुत महत्वपूर्ण भूमिका निभाती है कि न्याय सबके लिए एक्सेसिबल हो। नेशनल लेवल से लेकर तालुका स्तर तक लीगल सर्विसेज अथॉरिटीज, न्यायपालिका और सामान्य मानवी के बीच सेतु का काम करती है। मुझे संतोष है कि आज लोक अदालतों और प्री लिटिगेशन सेटलमेंट के माध्यम से लाखों विवाद जल्दी, सौहार्दपूर्ण और कम खर्च में सुलझाए जा रहे हैं। भारत सरकार द्वारा शुरू किए गए लीगल एड डिफेंस काउंसिल सिस्टम के तहत केवल 3 साल में लगभग 8 लाख क्रिमिनल केसेस का निपटारा किया गया है। सरकार के इन प्रयासों ने देश के गरीब, दलित, पीड़ित, शोषित, वंचित को ईज ऑफ जस्टिस सुनिश्चित किया है।
The Prime Minister also used the occasion to highlight the importance of legal awareness, observing that a poor individual cannot truly access justice until they are aware of their rights, they understand the law and overcome the fear of the system's complexity. He affirmed that enhancing legal awareness among vulnerable groups, women and the elderly remains a key priority. Further, the Prime Minister stressed another important aspect of legal aid, that justice must be delivered in a language understood by the recipient. He said this principle must guide the drafting of laws, as when people comprehend the law in their own language, it leads to better compliance and reduced litigation. So with a focus on these key aspects highlighted by the Prime Minister, the need to strengthen legal aid, promote legal awareness and ensure ease of justice for citizens, we will now turn to discuss the steps taken in recent years, also the way forward. Joining me are two distinguished guests. I'm pleased to welcome in the studio Mr. Sangram Patnaik. He's an advocate, Supreme Court of India. Thank you, sir, for joining us on the program. And joining us virtually is Dr. Vageshwari Deswal, Professor, Faculty of Law, University of Delhi. Professor, delighted to have you with us on this edition of Perspective. Welcome to the program. So there are so many pillars of strengthening legal aid that the Prime Minister touched upon. Let's discuss them one by one, beginning with accessibility and the foundation of social justice. So, Mr. Patnaik, to you first. You heard the Prime Minister talk about and particularly stress on how justice truly becomes the foundation of social justice only when it is accessible to all and it's delivered in a timely manner. To begin with, and from your experience as an advocate, tell us about where do the biggest bottlenecks in India lie as far as accessibility is concerned?
See, madam, I'll tell you, Tina, madam, you are such a learned person. You know, this development that has taken place, I must say it is no less than achievement, which is probably the posterity would remember. Number two, this legal aid, the services that has to be given to these all poor, downtrodden and the marginalized, the persons who belongs to this poor class, would be provided at the doorsteps. See, I'll tell you what, 1963, the judgment of the Supreme Court, where it says that every citizen of the country is entitled to the legal services, whether with cost or without cost, right? And there it starts that how to provide the legal aid systems, the poor, downtrodden or the marginalized people. In our Constitution 39A also provides that everybody is entitled to the legal support, whether you have money, whether you are a poor with caste, creed, religion, anything. It is not going to debar you from accessing the justice. Now, my point is, earlier we do not have this kind of system where you would say 8 lakh cases has been disposed of in 3 years, mind it, 3 years. It is an achievement which probably nobody can compare with regard to the 8 lakh cases disposed of. I would not say that yes, whether successfully, whether there is a mediation took place, whether the plea bargaining is happening, but end of the day, 8 lakh people, the citizens of our country, has benefited of it. Okay. So therefore, I would say that this is a step in the right direction, and had it been so that yes, it would have been done earlier, then probably this backlog, the cases that is happening, the people are, in a normal situation, the citizen says, your courts are full of dockets, full of matters, where from you get the time to dispose of. But end of the day, if 8 lakh cases, particularly the criminal cases, mind it, where the trial is required, suppose you are a poor person, you don't get a good lawyer. See, the grievance is what for a common citizen? I don't get a good lawyer. I have to sell my all utensils, my assets to engage a good lawyer. Now that doubt would be over if you have trained lawyer. You can, provide them on the state exchequer expenditures. For example, yes, I have to engage a lawyer. I can go to this system and I will hire a lawyer who would not be charging anything, and that would be funded by the state. So these kind of things are very reformative, no doubt about it. Only the time will say that yes, what kind of quality of, the mediation process, the kind of lawyer that has been available in the states. Because earlier what happens is that, somebody would say that yes, this lawyer who is appearing for the state, defending as a defense counsel, may not be that equipped in terms of the knowledge and, wherewithal. But end of the day, if you have a trained set of lawyers, you get the same similar justice, whether it is a private defense system or from these government provided lawyers, then I would be happy to say that the entire legal system would be changed someday looking at this development.
Okay. Let's also bring in Professor Deswal into the discussion and the point that Mr. Patnaik is making. Professor, how do you see the idea of access to justice particularly having evolved beyond just legal representation? How much progress, according to you, have we made towards making our legal system more holistic, more inclusive, because that's what the idea is, and most importantly to make the citizens aware of what the system is, what their rights are, and when their rights are not fulfilled, how do they make use of the system?
Legal aid was pioneered by Justice Krishna Iyer. We got the law in 1987, this NALSA Act, but it was implemented in 1995. So now, while celebrating the 30th anniversary of this landmark legislation, which has actually brought justice to the doorsteps of our people. See, when we talk about accessibility, what legal aid is doing is now I don't need to go to the courts, the justice is coming to me. How is that happening? See, engaging a lawyer, legal advice doesn't come cheap. So whether you want advice, whether you want to hire a lawyer to represent you before the courts, this entails the process fees, the fees that are to be paid to the witnesses for attending the courts. Now everything is taken care of. Earlier, people used to be very skeptical when we used to talk about legal aid, that maybe it is only those lawyers who don't have a flourishing practice who are empaneled with the legal aid. But now the situation has changed. We have good lawyers, and there is a choice with the litigant that if you are not happy with this particular lawyer, you can make an application, and then the presiding officer and the authorities, they can decide whether you have to be, that particular lawyer is to be assigned to your case. When we talk about further spreading awareness regarding legal aid, So this is something which is being done through digital media, print media. See, I am a professor in Delhi University. All law schools, all universities, it is mandated that we have a legal aid clinic running in our universities or law centers. And what do? We train our students to become paralegal volunteers. We take those students to different places, rural areas, bastis and all, where these students, they help people. They ask people that what are the problems, and then they give them legal advice. They also coordinate with other empaneled lawyers to get them legal advice and also to facilitate how they can access the courts. See, these students, they also visit prisons. There, if there is a prisoner who wants to apply for bail, or there are various other rights and all that they want to talk about. So these students who are trained paralegal volunteers under the aegis of NALSA, see, we have this district legal services authorities, state legal services authorities, they hold these training camps. In addition to that, after we got the Mediation Act in 2023, now we are also facilitating community mediation. See, various states, they are preparing these SOPs, which are standard operating procedures. And according to that, community mediation is also being organized in local matters, wherein there is a neutral third party who helps to facilitate communication between the parties and reach an amicable solution. So what I feel is this legal aid which has been facilitated through this autonomous body, which is NALSA, under the aegis of the Ministry of Justice, Department of Justice, Ministry of Law and Justice. Now that's an excellent initiative. And when our Prime Minister puts his weight behind such schemes, I'm sure we are going to take it to the grassroots level.
Absolutely. And when the Prime Minister emphasizes that justice cannot be accessed by those who are unaware of their rights, it's quite significant to hear how universities and the academic institutions are playing a proactive role as far as spreading digital or legal literacy is concerned. A related question, Mr. Patnaik, to you on how are the practicing lawyers or the bar associations contributing to building this culture of legal awareness, because it has to be done by every stakeholder. Only then we can talk about the legal awareness and the legal rights reaching every citizen of this country.
See, this is one of those initiative, I must say, everybody is lauding this initiative. But of course, there is a challenge also. Like how to reach to this rural area where there would be internet connection, and you must educate them. That's the basic thing. Suppose I must know my rights, what's my fundamental right. So a villager, a farmer, they must know their right. And secondly, we must reach, like the madam said just a moment before, that the legal system must reach rather than they would coming to the legal system to taking help. Suppose telemedia, for example, a lawyer would be available on telephone to answer your queries. Where in the world you would see that yes, a lawyer is available on drop of a hat and he would be answering your queries. So that is absolutely new, and it would be very challenging that yes, I must know my rights, so therefore I can ask the lawyer. Second, I must say that with regard to the community mediation, which is quite a new thing, I must say, 70% of the disputes in India are petty nature. The civil disputes particularly are very petty. So which can be actually sorted out in the community, where there would be independent mediator who can go for the mediation and you can sort it out. So what would be the net result is that you would be actually, 70% of the cases would not be coming to the court. So it is not going to clog the wheels of justice. First advantage. Second advantage is that the gentleman would not be spending money to come to a city or come to a court to fight it out, engage a lawyer, because it is available there in the community. So there is a civil dispute, for example, there is a boundary dispute, right? You need not have to approach to the district court to sort it out. If it is available there in the same community, the community leaders are sitting and they are deciding this issue. I think it is one of those, achievement which probably after 10 years or a decade or 2 decades, we would say that at least all those cases which need to be fought in the court of law, which is actually should go to the court of law, are going to the court of law, not these petty matters. And that would be a remarkable achievement. The decision taken today by the Honorable Prime Minister would remain forever, at least in each day in the history, to say that yes, because of this reason, the courts, the dockets and the matters are actually reduced down.
So while awareness, legal awareness and empowerment is extremely important, another related aspect that the Prime Minister made a strong case for while delivering, the speech at the National Conference on strengthening legal aid and empowering citizens through ease of justice, he made a strong point towards delivering justice in the language that the citizens understand. So Mr. Patnaik, from a practitioner's point of view, how feasible is it, given the current state of the Indian legal system, to implement multilingual delivery of justice from drafting of laws to the judgments, the final judgments that come across? And what are the challenges in a system which pertains to a country as large, as vast as ours?
Tina Madam, you are rightly hit the nail on the head. It is a challenge, no doubt. 80,000 judgments to be translated and has already been translated in 18 Indian language. It's no mean an achievement, right? Because if you go to Kerala, if you go to Jammu or go to Odisha or to Bengal, that same language, right, which I can understand. See, what is the critics say? Like, you go to the court, you argue in English, I can't understand what my lawyer has argued. So pity, I must say, that today we are living in this 21st century. The litigant could not understand what the lawyer argues inside the courtroom. And now because of this, I must tell you, at least the litigant which poor, who doesn't know how to read English, write English or speak English for that matter, could able to understand what has happened in his matter. For example, evidence. You do a cross-examination, right? And you would be good at your English, right, as a lawyer or whatever, professional. But the litigant who comes to you for safeguarding his interest in the court of law, applying the principle of law, what he could able to make out. If he can't make out, he's actually the consumer of justice, right? We are a part to the system, we are all stakeholders. But the person who has come to the system could not understand a single bit of English. So now at least, if it is translated into his own language, he can say that today I have gone to court. When he goes back to his home, he would say, today I have gone to court and my lawyer has argued in this language and I could able to understand. We may win the matter. So that is actually the litmus test when the consumer is understanding the provisions of law. That is one. Secondly, it is not that it is a very, you would say that English is a language which everybody should follow. It's not like that. And then the most important part, I would say, the litigant understand whether he is getting justice or not. Right. The conversation between the witness, judge and the lawyer is being understood by the litigant who is present inside the courtroom. That is the test and we are going to achieve that test.
In fact, before we proceed, before we get in the professor's comment and remark on why it's important to have justice in a language that people understand, let's listen in to what the Prime Minister said about some of the steps that have been taken towards ensuring this in recent years, but at the same time, why it's important to implement it at the national level. Listen.
लीगल एड से जुड़ा एक और पहलू है जिसके मैं अक्सर चर्चा करता हूं। न्याय की भाषा वही हो जो न्याय पाने वाले को समझ आए। इसका ध्यान जब कानून को ड्राफ्ट किया जाता है तब रखना बहुत जरूरी है। जब लोग कानून को अपनी भाषा में समझते हैं तो इससे बेटर कंप्लायंस होता है और मुकदमेबाजी कम होती है। इसके साथ ही यह भी आवश्यक है कि जजमेंट्स और लीगल डॉक्यूमेंट्स को स्थानीय भाषा में उपलब्ध कराया जाए। ये वाकई बहुत सराहनीय है कि सुप्रीम कोर्ट ने 80,000 से अधिक जजमेंट्स को 18 भारतीय भाषाओं में अनुवाद करने की पहल की है। मुझे पूरा विश्वास है यह प्रयास आगे हाई कोर्ट्स और जिला स्तर पर भी जारी रहेगा।
Professor, taking forward the discussion on this aspect, that justice should be delivered in a language that the citizens understand. For years, we've seen how, because of the complexities that prevailed within the system, the citizens were kept away from being part of the system. Now, when we talk about awareness, now when we talk about ease of justice as the third pillar, in addition to ease of doing business and ease of living, what role can legal education accompanied by technology play in bridging that language divide that persists in our systems, so that the citizens can truly understand, they can truly in multiple ways own the laws that they live under?
Yeah. See, Tina, language is just a medium of expression. But over the years, what has happened is English has been assigned such a place of privilege. Moreover, the way laws are drafted, the way we use the legal language consisting of a lot of heavy words. So what has happened that anyone, any lawyer, the way we have been educated, the way we've been given a formal training in law, we have somehow developed a mindset that unless and until I drop some very technical and formal words, maybe I will consider to be less of a lawyer. So this is one thing that we need to get rid of while we counsel our clients. Towards this end, the initiative that has been taken by the Supreme Court of translating the judgments in local language, it's an excellent step. And let us hope that the high courts and the district judiciary also follow suit soon. Now, why this is mandatory is, see, I get an order from the district court, but I'm not able to read the order. Not in the technical sense. See, I can read the order, but I don't understand the terms. Whatever the lawyer tells me, I have to accept it on the face of it. And lawyers, they don't have that much of time so as to explain to their litigants each and every nuance of what the judgment entails. So this translation is important. Then we have launched so many services. There is this tele-law service in which you can get this legal advice on telephones also. Then there is a web portal for prisoners also on which they can seek legal advice, they can apply for legal aid. So technology is coming very handy. Then we have also, see, now all the laws, earlier you would have to visit the law libraries and only then you could get hold of the statutes. Now those statutes, they are available online. You can easily translate them into the language in which you want to access them and understand them. So ease of language is extremely important so that people know what the law is. Otherwise, what happens in courts? I narrate my problems to the lawyers. Now, what the lawyer is presenting before the judge, the litigants, they feel isolated. Their own case seems to have been taken out of their hands, because when the lawyers argue the case in an alien language, what is the relief that is being asked for? What are the provisions that are being invoked? A litigant who is not aware with the technical and formal language, he feels isolated. So towards that end, translating the laws in the local languages, thereafter encouraging courts to hold their proceedings also in local languages, translating the judgments so that we all are aware of what is happening and the litigant basically does not feel alienated. That would be very important to make him an integral part of the legal system, and so that he feels confident about approaching this legal system.
That's right. You absolutely put it correctly, how technology is playing an important role in bringing about that transformation. In fact, the Prime Minister did emphasize that technology is a disruptive force today, and especially when it carries a pro-people focus. He emphasized how technology has become a powerful tool for democratization in India, linking it to the UPI revolution. Before we proceed, let's play that soundbite for you.
टेक्नोलॉजी निश्चित तौर पर एक डिसरप्टिव शक्ति है, लेकिन अगर उसमें प्रो पीपल फोकस हो तो वही टेक्नोलॉजी लोकतांत्रिकरण की शक्ति बन जाती है। हमने देखा है कि कैसे यूपीआई ने डिजिटल पेमेंट्स में क्रांति ला दी। आज छोटे से छोटे वेंडर्स भी डिजिटल इकोनॉमी का हिस्सा बन गए हैं। गांवों को लाखों किलोमीटर ऑप्टिक फाइबर से जोड़ा गया है। अभी कुछ सप्ताह पहले ही ग्रामीण इलाकों में एक साथ लगभग 1 लाख मोबाइल टावर शुरू हुए हैं। यानी टेक्नोलॉजी आज इंक्लूजन और एम्पावरमेंट का माध्यम बन रही है। जस्टिस डिलीवरी में ई कोर्ट्स प्रोजेक्ट भी इसका एक शानदार उदाहरण है। ये दिखाता है कि कैसे टेक्नोलॉजी जुडिशियल प्रोसेस को आधुनिक और मानवीय बना सकता है। ई फाइलिंग से लेकर इलेक्ट्रॉनिक समन सर्विस तक, वर्चुअल हियरिंग से लेकर वीडियो कॉन्फ्रेंस तक, टेक्नोलॉजी ने सब कुछ आसान कर दिया है। इससे न्याय मिलने का रास्ता और आसान हुआ है।
Okay, so let's come back to the discussion, Mr. Patnaik, taking on from where the Prime Minister left it at. Technology aided with significant transformative reforms that we've seen over the past 11 years. They've brought about significant change in multiple areas. UPI revolution was one such example that the Prime Minister quoted at the event. But the question now is, as we move towards our Viksit Bharat goal, we want to see India become a developed nation by 2047. What must be the next phase of judicial reforms to ensure that ease of justice becomes as impactful, as meaningful as, say, ease of living or ease of doing business has over the past decade?
See, earlier days I have heard ease of doing business, though after 2020 it was dropped. But ease of getting justice is a phenomenon. Probably all of us would agree and accept this as on date. There are three important aspects. I must say that paperless court system, right? Prior to COVID, I can tell you about the Delhi or the Delhi courts or the Delhi High Court, or, we used to carry the file as a matter of practice to the court. But as on date, you don't carry the file, right? Everything is available on your laptop or on your iPad. You do the matters, you attend the matters, and 1,000 pages or 2,000 pages, it is available on your click of a mouse. The advantageous point is that everything is paperless, everything is available on your doorstep. The most important parts, for example, I'll give you a practical example. When you file a case, you have to serve the other side. In good old times, not good old times, even 10 years before, there is a registered AD, speed post AD, you have to serve the other side, then only it would be considered a valid service on the other side. Now, I'll tell you practically what is happening today. Even double click in your WhatsApp considered to be a service on the other side. Tell me, if somebody is in US, you wanted to serve the other side the summons electronically, by email, by WhatsApp, or whatever means and manner. How easy it is from a convenient point of view that you serve the other side, they must come back to the court and answer their part of story, right? But what was happening earlier? Some smart people would avoid the services, then there would be pasting, then there would be dim service, and then he would say that no, otherwise if you are not coming to the court answering your version of story, then you will be proceeded ex parte. Now those things are over. Now the practice is, if I have to file a case against you, I have to serve you by electronic mode, by whatever means and manner. But then once you are served this double click business, then you are considered to be, the service is affected on you. These are all practical aspects which you see day in, day out in your life. And for example, having the judgments, for example, we are subscribing AIR, SEC, DLT, all those things, I still remember 30 years before when we joined our bar, then we used to search manually, right? Today, click of the mouse, you get every judgment on one aspect without making any effort. Of course, there are advantages and disadvantages.
You're right. So both in terms of policy, but also aided by technology, we've made significant progress, Professor. But, as a professor of law, if I am to wrap up the discussion and ask you, if you were to suggest one actionable reform, because this has to continue, we have to keep progressing if we have to realize that vision of 2047, what would you recommend to make justice more fast, but also fairer in our country? And with that suggestion, we'll wrap up the program.
Yeah, as Mr. Patnaik rightly commented, now there are e-FIRs, e-summons, e-notices that can be served electronically. But to my mind, what I find the best procedure would be to adopt mediation as far as practicable, in which we have a neutral third person who just helps facilitates the conversations. The parties get to choose their own solutions. See, if they are not happy with the settlement, if an amicable settlement cannot be arrived at, they can always send the case back to the courts. So this is going to save a lot of time. This is going to save a lot of energy, money, and all that is being spent on needless litigation. Let the parties come to a table. Let them just thrash out their differences with the help of a neutral person who tells them what the law is and what possible solutions are available in accordance with the law. Right. So what I feel is once we've got the Mediation Act of 2023, the only thing is that we need to facilitate more and more mediation centers that we are already doing in our law schools.
You're right. In fact, in this regard, I recall the Prime Minister did mention that mediation has been an important and integral part of our civilization, and the new Mediation Act does carry forward this tradition. It just gives it a more modern form. We'll have to wrap up the conversation. Time allows us to take up only that much on the program. Thank you once again, Mr. Patnaik, Professor Deswal, for joining us and giving us such valuable insights and inputs. With that, it's a wrap on this edition of Perspective, viewers. Thank you very much for your time as well.
To watch more programs of Sansad TV, subscribe to our YouTube channel and don't forget to like and share them.